Hey, good afternoon, everybody. It's David Feeks here at the Parents Estate Planning Law Firm in Acton. Apologize for the sun draping across my shoulder. It is now what's become a rare event in New England. We've got a sunny day here. It has not been sunny very much over the last few weeks. Today, I just wanted to pop in and talk to you a little bit about a question that we get very often, and that is what happens if I die without a will? And what happens to my money? What happens to my stuff? Sometimes what happens to my kids? Um, Usually it's framed in a part of a broader question, which is what happens to everything if I don't have a plan in place. But always a component of that is what happens if I die and I don't have a will in place. And the most important thing to know is essentially if you die without a will, without any plan in place at all, but particularly if you die without a will, you've lost control over what happens to your money, what happens to your assets, what happens to your real estate when you die. And when you die without a will, you die what we call intestate. And what that means is without a will. And state rules take over, and state laws take over. And state rules basically dictate what's going to happen to your money and to your assets. Now, the result sometimes, I would say even often, it might align with what you would want to happen anyway. If you wanted your spouse or your kids to get your money or your assets, that's often going to happen, most often going to happen by default in any event. As I often explain to clients, even without a formal will in place, to married clients, even if you don't have a formal will in place, your kids are your heirs at law, and the resources you leave behind will be held and preserved and managed and used for their benefit. But even if that happens, it's not necessarily going to happen the way you want it to happen, because you've lost the ability to dictate how things should happen. So the number one thing to know is that without a will, you lose control over, number one, where that money goes and how that money passes. Now, for a lot of people, they might not want all of their kids to get their assets. Certainly in a second marriage with blended families, you may want your kids to get your assets, and the agreement may be your assets will go to your kids and your spouse's assets will go to their kids. But if you don't have a will in place, a spouse may have an automatic right to a portion of your estate, and so your kids may end up with less than you would want them to have. And really the only way to counteract that is to create a will which gives you fine control over what assets go where and when and how. So the number one thing to know is you've lost control over where your assets go. Number two, you've lost control over who manages that process. So having a will gives you the ability to name someone. In Massachusetts, we call that person a personal representative. To name someone who's going to be the go-between between your estate and the probate court. Because if you have a will and your assets are passing under a will, they're going to go through the probate court. And there has to be someone who manages the process between your estate and the court. And again, in Massachusetts, that's a personal representative. And when you create a will, you name someone to serve as your personal representative. And if that person can't, usually you name an alternate as well. But if you don't have a will, you don't have a named personal representative. Now, there still has to be a personal representative, but now this person is simply going to be appointed by the court. And so it may not be who you would want it to be. It's probably not going to be who you would want it to be. It may even be a stranger. And sometimes it may even be a creditor, because even a creditor could petition the probate court to be appointed as a representative of the estate if there is not another obvious candidate. But without a will, you're losing the ability to decide who you want to manage all of the affairs that are being supervised by the court. Now, if you've got minor children, there's two other big problems with not having a will. Number one, a will is the way that you name permanent guardians for your kids in the event you die. And if you don't have a will, then you don't have that mechanism to name permanent guardians for your kids if you die. So you've lost that ability to name guardians through your will. And as important, you've lost the ability to decide who's going to manage those assets for your kids. So, for example, if you are married and you have minor kids and both you and your spouse die, and neither of you have a will, number one, the court is going to appoint people to serve as permanent guardians for your kids until they turn 18, and it may be who you would choose, but it may not be who you would choose. So you've lost control over who that's going to be. And the court may choose the person you wouldn't want to be the guardians of your kids. And as important, because your kids are minors, they can't inherit assets directly until they turn 18. And so the court has to appoint someone to manage, essentially a trustee, to manage those resources for your kids, to take care of what they need: healthcare, education, food, clothing, shelter, paying for college tuition, private school, whatever it is. If you don't have a will, the court has to appoint somebody, and it's almost guaranteed to be a stranger, because the courts keep lists of people who serve in that kind of role on an ongoing basis when needed. So the courts know who this person is. They know this person has experience like this managing money. This is a person who's almost always bonded, so is ready to go when appointed by the court. And what I always have to explain to prospective clients is, if you don't have a plan in place, even if the right person is taking care of your kids, there's going to be someone else who's managing the resources for them. And so your guardian is almost guaranteed to be dealing with a stranger who's managing the money for your kids. And then the last thing to know, if you have minor children, about not having a will, is that even if all of your assets are going to go to your kids, it's not somehow going to go to somebody you don't want. It's going to go to your kids. Without a will in place, it's going to go to your kids automatically when they turn 18. So with the default plan in place, it's going to go to your kids on their 18th birthday. And you may not want your kids to get assets at age 18. They may not be financially mature enough to make wise decisions about what to do with those resources when they're 18. You may want them to be 25 or 30 or even older. And again, without a will, you've lost the ability to set out in your will exactly how you want those assets to pass to your kids. Do you want it all to go to them at one age? Do you want it to be those distributions to be staggered and paid to them over a series of ages? Maybe a little bit when they graduate from college, more when they're 25, more when they're 30. Again, a will gives you this granular control over how you want those resources to be distributed, how and when you want those resources to be distributed to your kids. And again, you get complete say in who's going to be doing the managing of all of that money. So it doesn't have to be a stranger. You can appoint someone in your will as the person who's going to manage the money for your kids until it gets distributed to them. So just like you can appoint the person, the personal representative, who's going to manage the court process of your estate, you can appoint the person who's going to continue to manage those resources for your kids, again, until it's ultimately distributed to your kids. So those are all of the things that you can do with a will in place that you can't do if you don't have a will. You won't have control over where those assets go. You won't have control over who's managing that court process and that administration process. You won't be able to name long-term guardians for your kids in the event you die, because you need a will to do that. You won't be able to decide who's going to manage those assets for your minor children until they're old enough to receive them, and you won't have the ability to say, this is when I want my kids to get these assets, and these are the circumstances under which I want my kids to get access to those assets, and how I want those assets to be managed until they get an outright distribution of those assets. So, a will is the foundation of any estate plan. Even in a trust-based plan, and a lot of our clients have plans that include a revocable living trust as part of their plan, they would still have a will. Because even with a trust in place, a will is how you name long-term guardians for your kids in the event you die, and then the will serves as a backstop to the trust to catch any asset that's not already in the trust and to funnel it into the trust. So that's essentially the answer to the question, what happens if I die without a will? Bad things can happen. Now, if you want things to be as easy as possible for your family, if you want things to be as clear as possible for your family, if you want there to be no question about what's going to happen to your assets, who's going to get them, and who's going to manage everything until all of your assets get to where they're supposed to go, then number one, you need to have a will in place. Now, if you don't have it and you need and want to know, hey, what could be the next steps to getting in this place so I have the certainty and assurance of knowing exactly what's going to happen and knowing that things are going to happen the way I want them to happen, not the way the court wants them to happen. How you can get started on that is by setting up an introductory call with our client services coordinator. Her name is Lori. She's awesome. You'll love talking to her. And we will drop in the comments below a link for you to get on Lori's call calendar. So you can self-schedule some time on Lori's call calendar, and Lori will talk to you, find out a little bit more about you, your family, what's important to you, and help you to understand how planning can help you and can really help your family and your kids, and help you to determine whether our firm would be a good fit for you to get started on that planning, and whether you would be a good fit for us to help you get started on that planning. We are primarily focused on families with young kids and also empty nesters. I have been the parent of young kids. I am currently an empty nester. Everything I built into the plans for my own kids is now something that we build into the plans for all of our clients. And now that my kids are both in their 20s and my wife and I are empty nesters, we know all about the changes that come along with that kind of transition and pivot point in your life, because it's happened to us. So if you'd like to take advantage of scheduling an introductory call with Lori, our client services coordinator, just look for that link below in the comments. Click on that link and it'll take you right into Lori's scheduling calendar where you can self-schedule a call with her. Also, in the comments below, let us know if there's a topic you would like us to cover on a future Facebook Live. We show up here on a reasonably regular basis, rain or shine. Today it's shining, to answer your questions and to talk to you and explain a little bit about estate planning, how it impacts you, how it impacts your family, and how estate planning can always make things so much easier for your family if something were to happen to you. So thank you very much for joining me today. If you are here live, thank you. It was great to see you. If you are watching this in replay, hopefully everything that we shared with you today is helpful. And again, if you want to hop on a quick call with Lori, just look for the link below and you can get yourself on Lori's calendar. It was great to talk to you all today, everybody. We'll talk to you again real soon. Take care.